What to say to an insurance claims adjuster after an injury accident? Well, after an accident, the insurance company for the person or business that caused the accident is going to have a claims adjuster call up the injured person and ask a whole bunch of questions. And most people think that the adjuster is going to figure out everything that needs to be taken care of and resolve the claim promptly and fairly. Unfortunately, that's not the way it happens all the time. Now, for somebody that's been injured and it's someone else's fault, you may run into two separate kinds of claims adjusters. The first adjuster is the property damage adjuster, and their job is to figure out the value of the vehicle, house, whatever, before the injury occurred and determine what it would cost to put it back into its pre-accident condition, or if it's a total loss, figure out what the total loss number is going to be. And this person is generally fine to talk to, as long as you don't talk to this person about how you're feeling, what your medical bills are, what medical treatment you've got, how the accident has impacted your life. You only want to talk to this person about the damages to your vehicle or whatever else was damaged in the accident. Now, once you work out a settlement with this person, it's going to be for the property damage only. So when you read the release, you're going to have to sign a release in order to get your check. The release should say that it's releasing all claims related to your, Buick or whatever vehicle or whatever it is. It should not say releases any and all claims resulting from the incident. It should not be releasing your bodily injury claims. So even if you hire a lawyer, a lot of times lawyers are going to say, hey, you know what, it's okay, go ahead and talk to the property damage adjuster, even though you've got a lawyer. So that is the easy question. Now, how do you talk to the other adjuster, which is going to be the bodily injury adjuster? Sometimes they go by different names, but this is going to be the adjuster in charge of figuring out the value of the personal injury claim. Well, they're going to ask you questions, but then they're going to tell you, hey, we want to do something called a recorded statement. And you might be thinking, well, you've been asking me questions all the time. What's different now that you want to put it on a recorded statement? The difference is with the recorded statement, anything you say can and will be used against you in a court of law. It's not exactly that, but the purpose of the recorded statement is the claims professionals working with their team of lawyers put together a list of questions, and they're going to read the script to you and ask you questions designed to either deny your claim or to minimize your claim. So, do you want to answer this? Probably not. If you have a really minor claim, you went to Quick Care and you've got a bill for a couple $100 and you're all better, well, maybe it's fine to go ahead and do that. But if you've got a claim of any kind of significance, you may want to be on a level playing field before you get in there and answer their questions for them. So you might tell the adjuster, hey, you know what, let me think about this and I'll get back to you. And when you're thinking about it, you may want to reach out to a experienced personal injury lawyer to get a little guidance with this. If you happen to be in the state of Nevada where I practice law, feel free to give me a call or drop me an email. I'd be happy to answer all your questions. It's no cost, no pressure, just answers. If you are in a different state, I do work with some lawyers in other states, so if you don't have somebody you already know there, feel free to give me a call and I'll do my best to point you to somebody that can help you out there as well.